So why do the libel laws frighten people and stifle people so much? You've probably heard this before if you've been following our campaign, but the laws in England and Wales are very unfair. 90% of libel cases are won by claimants. They're very, very complicated laws. Defences against libel exist, but they're very complicated. Even libel lawyers tell us they're hard to understand, and they couldn't tell you for sure whether you'd be able to use a particular defence in the law at the beginning of your case. Those defence and so many other things and so many arguments, and they're just so complicated. They're very much out of date as well. There's a part of the libel laws which is called the Duke of Brunswick law, which originated in 1849, and it's still on the books. And does, as you can imagine, in 1849 there was no Google, there was no Facebook. It hasn't kept up with the rise of the internet. They're very, very expensive. Because they're so complicated, they lead to very long arguments, really long pre-trial arguments before a trial even starts. And their libel cases are heard in the High Court in London, where legal costs are higher than they would be in the rest of the country. And libel lawyers have to be very, very specialist and very, very expert to understand all these rules, so their costs are high. So for many reasons, they're really expensive. Cases routinely cost about 200,000, sometimes cost 500,000, and they can cost more than $1 million, and they have cost 5 and 7 million in the UK. And libel cases in England and Wales cost 140 times more than the equivalent in mainland Europe. Because of those reasons, the laws have been criticised by so many bodies all around the world, including the UN Human Rights Committee, the Culture, Media and Sport Select Committee in the Parliament, the Ministry of Justice Working Group who looked at libel recently. They're criticised internationally, and international people care about them because people from all over the world can come and use the laws in London to silence their critics all over the world. These problems that the laws are needlessly complicated and unduly costly and liable to stifle debate have been recognised since the 1920s. But major reform has never happened. They've never properly been addressed. Piecemeal reforms have happened over the last century, but they've actually only just served to make things more complicated and therefore more inaccessible to most people and even more expensive. So right now...
Can I just ask, what country's libel laws would you say we should be following? Out of others, if others can come here. What is there?
There isn't a perfect libel law that I can see.
What would be the most perfect, though, in your view?
I'll tell you in a moment.
Okay.
There isn't a perfect one. Some people say the US law, because they have much, much more liberal libel laws, but they have some aspects of it that actually wouldn't be allowable in the UK because European law, I can explain that in a moment. So right now, they don't work for anyone. They don't work for people writing about things. They don't work for people who have had their reputation damaged either. Maybe for people in this room, maybe for Sense About Science. There are things written on the internet that are defamatory and lies about us, but we've never taken them on because we don't have the stomach or the financial clout to get engaged in possibly a 2-year-long libel battle to get redress for that. So people, citizens, people like us, people who care about open discussion of things, are paying a really high price in the lack of protection for freedom of speech, for a law that only protects the wealthy and powerful from criticism and does nothing to protect all of our reputations. So there's been huge strength of feeling for libel reform. Over 50,000 people have been mobilised in support. People who signed up to the campaign include Poet Laureate and the Astronomer Royal, top scientists, comedians, authors, publishers, academics, patients, bloggers, commentators, editors, everybody, people like us. Organisations that support us include medical royal colleges and royal societies, publishers, science professional bodies, NGOs including Amnesty, Christian Aid, Global Witness, the BHA and the National Secular Society signed up. Mumsnet signed up. Thousands of people wrote to their MPs before the last election. And last March, hundreds of people, including some people I see in the room here, came with us to lobby Parliament and asked their MPs directly, face-to-face, what they were doing to ensure that their particular parties voted in support of libel reform. And at that meeting in Parliament, Jack Straw told us it was the largest public meeting he'd seen in Parliament in all the years he'd been there. It's very exciting. The majority of eligible MPs signed up to an early day motion in support of libel reform in the last parliamentary session. We ran a fundraising gig, which a couple of thousand people came to, which sold out really quickly, which had 15 top names clamouring to be involved in it. Every national newspaper has run an editorial recently calling for libel reform. All of this support, all of your support, and all of the things we've all been doing meant that before the last election, the three major parties made a commitment to libel reform in their manifestos. And after the coalition government got into power, they committed in Queen's Speech to reform the libel laws to better protect freedom of expression, which is fantastic. Then last summer, Lord Lester of Herne Hill brought forward a private member's defamation bill designed to, he said, make the libel laws clearer and bring them up to date with the information age, and make the defences to libel clearer and stronger, including making statutory a defence for responsible writing in the public interest. That was debated in the House of Lords, and that was the first time widespread libel reform had been debated in Parliament ever. It was very exciting. 20 peers spoke in that debate, and that was, I think, the most speakers in a private member's debate for years. So there's such high feeling for reform. Everybody, so many different people are realising this is something that must be acted on. At that debate in the House of Lords, the Minister for Justice, who has responsibility for reform, who is Lord Tom McNally, who's a Lib Dem, announced that the government are going to bring forward their own bill. They're due to publish that bill in the new year. They're drafting it now, and we're feeding into it to make sure that it actually responds to the problems we've been seeing, that it actually protects these citizen critics and citizens like us who are writing about local authorities and local politicians and local issues from libel laws. The bill will be published in the new year, and then it will go to a scrutiny committee of both houses, and it could be legislation by 2011, and then it could take effect by 2012 or 2013. So it's been amazing to be involved in this campaign, which went from nothing a year ago to possibly legislation now. It's been absolutely fantastic. I don't think it's an exaggeration to say that we're on the cusp of history here. We're on the edge of something really enormous. But we can't let this momentum die out just yet. Where are we now? Now we have to make sure that the bill the government brings forward really does contain the really fundamental changes to the libel laws, to get rid of all the complexity and the uncertainty, to make them clearer and stronger and accessible for everybody. They have to have fundamental reforms so that we get the fundamental protection of free speech that we need. It has to be, we've been calling it amongst ourselves, a citizens' defamation bill. It has to protect the citizen critic and the bloggers and the kind of people sensitive about science who've been working with it for the past 10 years. It has to protect their ability to speak out. And recently we've produced this much needed leaflet, Reforming Libel, What Must the Defamation Bill Achieve, with the help of thousands of our supporters who, in response to an appeal last month, donated a tenner each to produce that document. We brought that to party conferences and we gave it to all the MPs, and it's a summary of what we want from a defamation bill, from a libel bill. What we want is, we need a clear public interest defence, so that writing on something in the public interest is protected from libel action. That's not necessarily because everything people say on a matter and public interest is true. Not necessarily. But a healthy democracy and a healthy society tends more towards noisy discussions and back and forth chat than silence. So there should be a presumption of publication on a matter that's in the public interest, and then a right to reply. Where we think there should be a restriction on corporations suing, in the spirit of a law that protects citizen critics and citizens. It shouldn't be allowable that corporate bodies can just silence people with the threat of an action. Corporate companies should have to prove there was some sort of recklessness or maliciousness in what somebody said before they can just drop a libel suit on them and silence discussion. And government bodies shouldn't be allowed to sue at all. They can now. Government bodies and schools and NHS can sue now if someone criticises them. The laws need to be brought up to date with the age of global communication and the rise of the internet. That rule from 1849 that I told you about, the Duke of Brunswick rule, is a rule came about when the Duke of Brunswick sent his steward down to the publishing house of a magazine and got him to reprint an edition of a magazine that came out, or a newspaper, a couple of years before. So the act of reprinting that magazine made the libel live again, because there's a one-year limitation when you can bring a libel suit against something. But the definition of publication hasn't kept up with the rise of the internet, so now a click on an article online starts a whole new one-year liability period, so there's a whole new fresh opportunity for libel. So we need to bring this so-called multiple publication rule to a single publication rule, so that the time you're allowed to bring a libel action against something is just 1 year. That multiple publication rule means that we know that people like academic editors and libraries and historians who are putting their archives online are putting them online with gaps in them, because they know there are stories or articles or peer-reviewed papers that might possibly be open for a libel action, so they're not pushing them up now, even though they may be published 20 years ago. They know if they put them online now, it's a fresh act of publication and they're liable to be sued for them again. So archives are going online with gaps in them. We also would like a defence of innocent dissemination, which means that internet service providers and website hosts are not held liable for something that's posted on them by someone who just visited their site. Because now they can be. So if you post something on Facebook and someone sues you for libel, Facebook are potentially liable as well and could force you to take it down. Internet service providers tend to do that if they hear there's a libel action against somebody who's hosted a website, someone whose website they host. They automatically just take it down because they're not any more educated in the libel laws than we are. And they sometimes find themselves, as someone from the Internet Service Provider Association told us, in the role of being judge and jury on things they're hosting, and that's not ideal. They don't understand the laws. They can't let themselves open for a suit. They just take things down. But if there was an innocent dissemination defence, writing which the writer might be willing to defend, will be left up there, not just dragged down with the Internet Service Provider immediately. What this all means basically is making the laws more accessible and affordable and more modern and fairer for everybody. Because until that happens, until the laws are radically reformed to include this public interest defence and a presumption of publication, then we will all continue, bloggers and citizen critics and people like us will continue to be silenced by legal bullies or to face financial disaster and years of fighting in court to defend words that we believe in. We still really want to hear stories from everybody on the impacts of the laws on anything you've done. Have you ever not spoken out as strongly about something as you think you should have for fear of libel laws? Have you ever avoided writing something or putting something online, or have any of your colleagues advised you not to talk about something? I realised a couple of months into the campaign that I was, when I used to be a stem cell researcher, affected by the libel laws, when I was going to talk about the high street company who runs stem cell banks, and a more senior academic in my department said, no, don't mention the company. Even everything I was saying was true and just based on science. They said, don't mention the name of that company. So, you know, you could be sued. So it's always surprising me where this gets to and how many people are being chilled by this and who it actually touches. And the more we know about that, the more we hear about the actual impacts of the libel laws, and the more evidence we get of that, the more we can feed that into the government to make sure the bill that they bring forward actually addresses those. As I said at the beginning, Sense About Science's aim is to equip the public with good science and to encourage scientists and the scientific community to get out there and take responsibility for reacting to pseudoscience and for addressing misconceptions in public debate head on. So we're pushing people out into the public debate. And now we know that we have to fight all the obstacles and the intimidation they find when they get there. That's why we're launching this campaign. Success for us, for Sense About Science, and for the libel reform campaign will only be when all of us, when scientists, when everybody else, are confident in their right to speak out strongly and in the right of free speech. Thank you.
Okay, so we'll now open the floor for any questions.